Okay, other falsities, Article 177, usurpation of authority or official functions. A person who shall knowingly and falsely represent himself to be an officer, agent, or representative of any department or agency of the Philippine government or of any foreign government, or who under pretense of official position shall perform any act pertaining to any person in authority or public officer of the Philippines, of the Philippine government, or of any foreign government or any agency thereof without being lawfully entitled to do so, will suffer the penalty of prison correctional in its minimum and medium periods. This is actually called usurpation of authority, no? Usurpation of official functions. Usurpation of authority. Sa man example ani police. Nay police nato sa imuha dili day police. Uniform, nay pusil. Ma'am, na ako'y pangutanan sa imuha, mag-imbestigar lang ko. Ngana, adlok po mga tao kay na ako'y pusil tapos papastig-astig ka dito. Dili day ka police. So kung nakabalo, hindi ko kapatuang police, padakop ka. Kaya you are acting as a police officer when in fact you are not. That's usurpation of authority. And Article 177 is being violated by knowingly and falsely representing oneself to be an officer, agent, or representative of any department or agency of the Philippine government or any other foreign government. So specifically, kung Philippine government ang imuang gina-represent niya, dili di ay. Part also kung ang pagka-officer representative sa foreign government could also be violating this Article 177, usurpation of authority or official functions. Muna to ang gist niya, no? You are pretending to be one officer when in fact you are not. Muna ang gist niya. And you are pretending to be doing that particular function of such officer when in fact you should not have done that because you are not authorized to do so. Muna ang gist Article 177. Let's go to Article 178. Using fictitious name and concealing true name, anti-alias law. Kaya ako kinumdum kung nabay kuan na tao nga na priso or na-file ang kaso sa korte ani, murag pedugay na, or di na siya kuan. Kasagaran sa mga tao ron ay angga. Angga is actually called alias, no? In fact, dito sa kuan sa mga kaso sa korte, People of the Philippines versus Jose Tampulano alias ata pa. So allowed, di ba? Naibutang alias so and so. Meaning allowed nila. Ano may demanda na may alias ato man na name na ato, nickname means alias. The penalty of Esto Mayor and a fine not to exceed 500 pesos shall be imposed upon any person who shall publicly use a fictitious name for the purpose of concealing a crime. Kana mo na ang purpose. The purpose of concealing a crime, evading the execution of a judgment or causing damage. No? Any person who conceals his true name and other personal circumstances shall be punished by arresto minor or a fine not to exceed 200 pesos. Pungutanong ka sa checkpoint. Sa pangalanin mo dong. Instead na imong pangalan, Richard Gomez, mayon ka Noel Velasco. Layo ra sa imong tinuod nga pangalan. Pagsulat dito, Noel Velasco. Na picturean ka, natimanan ka, Noel Velasco yung butang. Yung pala, pag-investigate na gud sa imo papakita sa imo ID, dili day kay Noel Velasco, Richard Gomez. You are violating this particular article actually, no? The elements of using fictitious name is that the offender uses a name other than his real name. That he uses that fictitious name publicly. The purpose of the offender is to conceal a crime, to evade the execution of a judgment, or to cause damage to public interest. Mo na ang purpose. If you are using another name without harming anyone or damaging anything, wala problema na. Kung makadamage na ka, o nalakay na harm, tapos nalakay gitaguan na crime, that's why alias ka, wala ang problema ka ron. Diya ka naka-violate. Kung wala kay gitaguan, pasana, sigurado man yun, nga akong angga, kaloy. Biano Bustamante, pero ang yanga, ang tawag sa kuha kaloy. Layo ano? Pero maman ang tawag sa kuha lang. Dahil lang kung kaso, People of the Philippines versus Bibiano Bustamante, alias kaloy dyan ko. Asa po na nila kuha ng kaloy, no? Ano daw? Nakaloy daw. Yes, Tristan Alice now, yours in your hand. What? Curfew. Oh, sulti yung pangalan. Kana, igo, dyan ka na. Labi lang, curfew karon is 10 to 4, di ba? Sa curfew manggod, na may mga qualifications, dira. Madakpan ka sa curfew, paingon ka sa trabaho, or gikan ka sa trabaho, kwan man na siya, excuse man na, hatag lang ka ng justification. Na klase? O, siyempre, excuse, tipim. Atang ka curfew, alas 9 na. Sa dalan, alas 10, paingon ka sa yung balay. Ayaw lang, pag inom-inom na. Ang curfew nito, inom-inom ka, dakpan dyan ka. Gikan sa klase, justified man ka, nga payon ka sa yung balay, napta ka curfew. Wala, problema na. You just have to reason out. Of course naman, mga officers, di ba, sila unreasonable persons nga. Saka na may guidelines actually. Allowed ang mga tao nga payon sa balay, gikan sa work, gikan sa balay payon sa work. At that particular time, sa kalsada sila naptan. Wala, problema na. Di na sa guidelines nila. Exempt na. Padayo na. Pakita lang ID and then record lang nila just for record purposes. Pero isulti pa rin mong tinuot pangalan. Kaya kung di mo yung isulti mong tinuot pangalan, pasig maka-violate ka aning atong gidiscuss karon nga article. So, okay na. What is fictitious name? Any other name which a person publicly applies to himself without authority of law is a fictitious name. Nagi authority of law. Pasaan niya akong gihimo sa ako sa akong FB sa Facebook na ako. Bibiano Bustamante man ko. SBEB Bustamante. SBEB diya. Mo na fictitious na ako. Wala man yung tawag ng SBEB. That's what I used sa Facebook na ako. Nga naman. Kaya kung bibiano man ko diretso, dali na kayo ko search. Kaya Bustamante. Mas-search tayo. Sa kinsa lang maka-search. Pwede pa itaan ka ng hacker. Dali na i-search. Pero kung SBEB yung punta, libog pa sila. Na Bustamante daghan. Pero kinsa mandire. Nasa mandire. Nakuha na ba ko kanang sa estudyante na ako ba na yung utana. Gibutang kipost pa yun sa Facebook. Na nag-mention dito. Tapos SBEB Bustamante. Isa lang ka word ang gikuan. Gamit na picture mo po itong profile pic na ako. Aperte sukuan na ako. Yung naman ako ang profile pic atong mga panahon na. Wala ka ito manyata to. Kaya nag-comment dito, nag-PM sa akong estudyante. Bisag unsag istorya sa akong estudyante. Abi na sa akong estudyante, ako to. So kay SBEB Bustamante. Wala to ang nalay. Ang ilang. Instead na Bustamante, Bustamante. O ang ilang yun ang lalahi. Ito po sila nga ako to. Pero yung pamalibad na ako. Ma'am, wala mo ko na inaana. Ama na yun ni-report sa kuha. Wala mo ko na inaana sa imong estudyante, ma'am. Sa imong bata, wala mo ko na. Tarawa po. Ako pagtanaw na ko po. Mama niyo, gi-screenshot nila itong engagement nila ba na exchange. Pagtanaw na ako ang picture. Uy, ako mani. Scrutinize na kumayo sa ma'am. Lahi na yun. Bustamante ang gamit. Bustamante man ko. Dili lang magiging niya ma-duplicate ako ang profile na account kay kung dili ka kabalo sa ako ang password na 1234. Di mo ma-duplicate akong account. Sa dili mo mabala na akong password nga 1234, di mo may sudlan na ako ang Facebook, di ba? Tama? Kasulod mo sa akong account nga 1234 ang password, private na gani. Oto na, nito sila nga dilito ako, kay abigin lang ako to, lahi na ba akong ipag-istorya dito? Huwag nga to tawanan, sukuan na ako gi-block na niya, yan ang i-deactivate na niya yung account. Abigin nila sa ako. Ako mo to i-post akong yaw-yaw ko sa akong i-post diri sa Facebook. You can search my Facebook account. Lawa to akong ipang-post. Way, last year, yata to. Anyway, so if the purpose is for causing damage, it must be damage to public interest. If it is damage to private interest, the crime will be estafa under Article 315, Subdivision 2, Paragraph 8. So take note of the difference. The damage must be against public interest. Signing fictitious name in an application for passport is publicly using such fictitious name. Same, one example, signing of fictitious name to review hali instead of tulio in an application for passport is publicly using a fictitious name. To evade the execution of judgment or to conceal a crime, where a person takes the place of another who has been convicted by final judgment, is guilty of using a fictitious name, punishable under Article 178, and not of evasion of the service of the sentence, because the real convict alone is guilty thereof. Seems that such person is also liable for delivering prisoners from jail under Article 156. We have already learned this now by helping the escape of the real convict by other means. And by other means is that he's using the name of the person instead of that person using that particular name. And when his name is being used by another, pagpa-inspection niya na dili mo yung pangalan ang igamit dito, siyempre, nagagawas dyan siya, kaya dili man siya mawang convict. O niya, ang convict, ang nagagamit sa pangalan sa convict, ako man. So, ako ang violate using or delivering a prisoner from jail under Article 156, using, by helping the escape of real convict by other means. Concealing true name, that the offender conceals his true name and all other personal circumstances, that the purpose is only to conceal his identity. Separate siya separate nga violation. The same provision but separate violation of the provision. Second paragraph, di ba? Second paragraph, any person who conceals his true name and other personal circumstances shall be punished by arresto minor or a fine not to exceed 200 pesos. So kung pangutanan ko sa iyong pangalan, isulti yun na iyong pangalan. Basta wala kayo kadlukan, you tell your true name in any other official investigation. Distinction between use of fictitious name and concealing true name. In use of fictitious name, the element of publicity must be present. No? In concealing true name and other personal circumstances, that element is not necessary. The purpose in use of fictitious name is any of those three enumerated, no? To conceal a crime, to evade the execution of a judgment, or to cause damage. And damage na itong ginamention diri is public interest, damage to public interest. In concealing true name, it is merely to conceal identity. Article 178. Let's go to Article 179. Illegal use of uniforms or insignia. The penalty by arresto mayor shall be imposed upon any person who shall publicly and improperly make use of insignia, uniforms, or dress pertaining to an office not held by such person or to class of persons of which he is not a member. Like, naroon yung police officer ka. Of course, para mahiaan, dumutugin sa mga police officer ka, sanina po kang police officer ka sanina. And so, pagpailan mo mga police officer ka, you are now in violation of Article 175. 177, okay? 177, pagpaila nimo, you are usurping official function or usurping public official function. And then at the same time, so tuo sila nga police ka, kaya naka-uniform ka, you are also in violation of Article 179, illegal use of uniforms or insignia. So the elements of Article 179 are as follows: that the offender makes use of insignia, uniform, or dress. That the insignia, uniform, or dress pertains to an office not held by the offender or to a class of persons of which he is not a member. That said insignia, uniform, or dress is used publicly and improperly. So wearing the uniform of an imaginary office not punishable. So hence the insignia, if the insignia, uniform, or dress pertains to an office which does not originally exist, this provision is not violated. So false testimony na sa false testimony, no? Section 2. Sa maning false testimony, of course, testify ka sa korte, mamaka ka nito, klaro kayo na false testimony. And there are several forms of false testimony. But by the way, it is committed by a person who being under oath and required to testify as to the truth of the certain matter at a hearing before a competent authority shall deny the truth or say something contrary to it. Makakute siya, deny the truth or say something contrary to it. What are the three forms of false testimony? 1. False testimony in criminal cases. 2. False testimony in civil cases. And 3. False testimony in other cases. So tulo, criminal cases, civil cases, and false testimony in other cases. Criminal cases, there are two articles being covered. Article 180 and Article 181. False testimony in civil cases, Article 182. False testimony in other cases, meaning kung dili siya criminal case, kung dili siya civil case, could it be administrative cases, no? Administrative. May lain, no? Ulo naman, administrative cases. So, nature of the crime of false testimony. Falsehood is ever reprehensible, but it is particularly odious when committed in judicial proceedings, as it constitutes an imposition upon the court and seriously exposes it to a miscarriage of justice. So, kung mamakaka sa korte, then tuo po ng korte sa iyong pagpamakak, and later on, na found out nga imong gisulti dili dahil tinuod, kawayolit ka. So, let's discuss, no? Article 180, false testimony against a defendant. Talking about defendant here, we are talking here of defendant in a criminal case. Actually, dapat ang ibutan diri false testimony against the accused. So, pasagot kung defendant against the defendant nga false testimony, pasagot ang mga testigo ani taga-prosecution, no? Mga testigo sa prosecution. So, let's write. Any person who shall give false testimony against the defendant in any criminal case shall suffer the penalty of reclusion temporal if the defendant in said case shall have been sentenced to death. Kung namatay, kay mali ang imong pagka-istorya, ito po lang judge sa imong mali, o niya, sintensyahan siya pag kamatayon, post di ay, pwede ka pa-priso, mapamatudan, pwede ka pa-priso o reclusion temporal. Ang reclusion temporal is table penalties from 12 years and 1 day to 6 years and 1 day to 12 years yata is reclusion temporal. The penalty of prison mayor if the defendant shall have been sentenced to reclusion temporal or perpetua. So, ikan sa reclusion temporal to perpetua, penalty is prison mayor. Penalty of prison correctional if the defendant shall have been sentenced to any other afflictive penalty. And the penalty of arresto mayor if the defendant shall have been sentenced to a correctional penalty or a fine or shall have been acquitted. Acquit ba siya, no? In cases provided in subdivisions 3 and 4, this article, the offender shall further suffer a fine not to exceed 1,000 pesos. So, sa may mga elemento ani nga article 180, that there be a criminal proceeding that the offender testifies falsely under oath against the defendant therein. The offender who gives false testimony knows that it is a false. That the defendant against whom the false testimony is given is either acquitted or convicted in a final judgment. Convicted, ano to ang graduation sa penalty, kung convicted of death, reclusion temporal. Kung convicted of reclusion temporal or perpetua, prison mayor imprisonment. Kung convicted of other afflicted penalty, that would be prison correctional. Article 181, same criminal case lang yapon na false testimony favorable to the defendant. This time, namakak siya para dili mapriso ang defendant. Favorable, no? Any person who shall give false testimony in favor of the defendant in a criminal case shall suffer the penalties of arresto mayor in its maximum period to prison correctional in its minimum period and a fine not to exceed 1,000 pesos. Irrespective of if the prosecution is for a felony punishable by an afflicted penalty and the penalty of arresto mayor in any other case. Ang afflicted penalty is from prison correctional to death. Prison correctional to death. Ato yun lang cross-reference na nato na afflicted penalty. Nakalimut ako sa kung saan yung mga afflicted penalty. Basta one of the afflicted penalties is reclusion, temporal, reclusion perpetua, and death. Muna mga afflicted penalties. Those are afflicted penalties, and then afflicted penalties ang kaso sa pag-testify niya favorable to the defendant. Ang iyang penalty should be prison correctional in its minimum period and a fine arresto mayor in its maximum period to prison correctional in its minimum period and a fine not to exceed 1,000 pesos. Pero kung dili afflicted penalties, ang iyang penalty is arresto mayor. Any other case, basta dili afflicted penalty, below afflicted penalties, arresto mayor lang ang kaso. That is, if he testifies in favor of the defendant in a criminal proceedings. Let's go to another article. False testimony in civil cases this time, no? Dahil man yung civil case, ang wapa siguro makaagi ani discussed in criminal procedure the proof of evidence, the degree of proof of evidence. In criminal cases, the proof is proof beyond reasonable doubt. Sa civil cases, preponderance of evidence ang required nga evidence nga i-present. Preponderance, bro. Kinsay bukat ba? Ibang timbangon, bukat ni siya mo daw. Preponderance of evidence. Ang sa administrative cases, substantial evidence. Substantiate lang nimo ang imong allegations against the person, then you could have person be convicted, punished administratively. That is the case. Substantial evidence lang kailangan. Whereas in civil cases, timbangon jud ang i-present nga ebidensya sa complainant against the evidence of the defendant. Kung kisay bukat, mao to amo daw. So false testimony in civil cases, any person found guilty of false testimony in a civil case shall suffer the penalty of prison correctional in its minimum period and a fine not to exceed 6,000 pesos if the amount in controversy shall exceed 5,000 pesos, and the penalty of arresto mayor in its maximum period to prison correctional in its minimum period and a fine not to exceed 1,000 pesos if the amount in controversy shall not exceed said amount or cannot be estimated. So ay bot pasabot ani. Civil case manggod, ang subject mo sa civil case is damage, no? Damage caused to other parties. So mag-file ko civil case against sa tao, samot gi-injure ko niya in the past na siya damage sa gihimo sa kuha. Quantify na ako ang damage. File na ko siyang civil case. Ang kanang quantification sa akong damage mo nang amount akong file against sa iya, i-claim sa iya. Mo nang nag-mention na diri kung ang amount in controversy shall exceed 5,000 pesos. Of course, ani nga bala ko dugay na mo kay ni. Ang 5,000 pesos sa una dako na kay na mga equivalent to 50,000 siguro na karon. 5,000 pesos sa una. So mo na ang bot sa bot ano kung ang if the amount ang word dia is the amount of controversy in civil cases shall exceed 5,000 pesos and he testify falsely, no? In that case, whether in favor of the other or against the other, doesn't matter as long as you are there testifying in court and you are telling lies before the court. Well, irrespective of whether favors your testimony favors the complainant or it favors the defendant in any case, wala i-mention diri. Basta kaya nag-testify lang ka nga false. So yan, ang penalty is prison correctional in its minimum period and a fine not to exceed 6,000 pesos if the amount in controversy shall exceed 5,000 pesos, and the penalty of arresto mayor its maximum period to prison correctional in its minimum period and a fine not to exceed 1,000 pesos if the amount in controversy shall not exceed said amount or cannot be estimated. Dili ma-estimate, so minimum prison and a fine not to exceed 1,000 pesos minimum. Penalty of arresto mayor in its maximum period to prison correctional in its minimum period. Walay kalahiyan, dili siya ma-compare nga no, because circumstantial evidence is evidence nga dili gyud directly nakita sa tao. Murag ka ng ebidensya nga tumbok sa real fact ba, dili gyud katong tinuod direct fact. So kung testimonial evidence that is testified by the person na siya, mo na testimonial evidence. But may kag circumstantial evidence, it consists of several evidences including testimonial evidence, object evidence, documentary evidence to prove that the circumstance of the case leading to the truth, not necessarily the truth jud, ito na lead lang dito. Wala mo pasabot sa circumstantial evidence. Again, a circumstantial evidence consists of testimonial evidence, documentary evidence, or any other evidence, object evidence, that tend to prove the circumstances around the particular fact, not necessarily the fact. Ang testimonial evidence, mo po rin siyang, kung naik testimonial evidence nga magtumbok yung anang fact, dili na siya circumstantial. Kaya siya man ginakita, uy, nakita yun ako, nga gikuan niya, ginunggab niya, kita nyo na ako sa akong mata. That's direct evidence, no? Called from testimonial evidence. Nakita niya eh. However, kung ang pagka-istorya niya is, oh, hala, nakipag-abot na ko nito. Naggunit siya ka ng nag-hunting. Nakabulagta na itong tao, nagkadugo ang hunting. Ana, pula na ang hunting. Dugugin siguro to. Wala siya nakakita ang hidunggab. Kasi hidunggab, nagunit lang siya sa hunting. Nanay na nakabulagta na tao. He's not testifying on the actual fact, but on the circumstances. This circumstantial evidence ayan, surrounding the actual fact. Kinsa gyud ang actual fact ato kinsa ang nadunggab. O ano nyo? So, Bilarmino, did I answer your question? Klaro kayo ha, bantay ka lang, di mo klaro. Anyway, so you can raise any other questions if you want, no? Just raise your hands. Elements of this particular article: that a testimony must be given in a civil case, that a testimony must relate to the issues presented in said case, that a testimony must be false, that the false testimony must be given by the defendant knowing the same to be false, that the testimony must be malicious and given with an intent to affect the issues presented in said case. Ay na case, no? Grabe to. Kaso gid ba? Laban jud. Grabe po na akong opposing counsel, mubanat yung mayo. Objection nyo, tira yun ka ng mga evidences ba? But my case was that, my client is charging that particular person, kalaban na mo, with oral defamation. Oral defamation, istorya siya di mao. So, gitrial na. Ang trial karon kay, siyempre, i-prove mo sa oral defamation is that, nakita nyo din mo, na dunggan nyo din mo na istorya siya, atubangan sa ubang tao mo, ginag istorya niya. Basta may question karon nga, layaro kayo sa topic, layaro sa karang pag-prove yun sa, dili relevant ba? Di ba, nagtanong siya, di ba, nanamoy nag-ato ba ka sa barangay, nakaingon mo akong kliyente, wala ko kayo naman mga ato ko sa barangay, pero nag-ato yun sa barangay, nakalimot na sa istorya. So, kato lang nga matter, nag-file na po siya kaso sa akong kliyente, charging, tawag ka ni, ato, karang false testimony or perjury ang i-charge sa akong kliyente. Grabe, gi-fight na mong perjury. While we are fighting for defamation against sa iyang client, gi-fight po na mong perjury against sa akong client. Grabe ito nga kaso ba? Dabu-dabu yun. Anyway, pildi ko sa akong client kay pailan napildi ko wala pa before na human among kaso dito sa lower court sa testimony perjury sa akong client, ako gipa-inhibit ang court kay nagpabor naman siya sa kalaban. Naman siya yung mga bias. So, papainhibit na ako, sugot lahat to mi sa laing court. Ito, nag-trial yun sa laing court, binutangay, dinabuhay, and then finally napildi ko akong kliyente. So naigoog ka ng perjury akong client. So pero dili ko mo surrender kay klaro man gyud sa ako nga dili man related ang iyang ipangutaan na gigiansaran sa akong client. To the point, in fact, ang point ato sa defamation is that tinuod ba ang istorya niya nga defame na yung client? Dili tong side question nga nag-ato ba ka sa barangay pag-file aning kasuhan hay nata. Dili na siya mapapprove sa kaso. Mao to akong ipanghawakan, no? So dili ko ni fall sa false testimony in criminal cases, criminal case man to. But dili gapon ako ang element to that the false testimony must be given, that the testimony must relate to the issues presented in said case. Relate to the issue. Ang issue lang ato is oral defamation. Tinuod ba nga masagad sa istorya sa kliyente? Ano itong issue? And then, ang question niya, nag-file ba ka o dito sa lahi na siya nga issue. And it's not related to the main case. And pag-appeal na ako na sa korte, paboran ko sa court na dismiss ang kaso, acquitted ako kliyente. That was the beauty of that case na labo-labo, tapos in the end, mudaog ka. Pero paningkamutan dyan yung mayo ba? In the end, no? So, that was the experience that I cannot really forget. I can still relate clearly sa mind ako under this particular articles. So, example sa post-testimony civil case. During the trial of civil case number 1692 in the Court of First Instance of Iloilo, wherein Juan Abraham Jr. sued Vasquez for some 9,000 and odd pesos, the balance due on account, the latter produced an alleged receipt for 8,700, which he alleged had been signed and delivered to him by Juan Abraham Jr. and testified under oath that he had paid him this amount. The receipt was not genuine and Vasquez had not paid the 8,700. So, false testimony jud, no? Article 183, false testimony in other cases and perjury in solemn affirmation. Now, take note of this, perjury and false testimony are two different things. While false testimony in other cases is done in violation in hearing of the court or other administrative quasi-judicial agency, kaning perjury, lahi ni siya. Perjury is kanang mag-execute kay kag affidavit, tapos sa affidavit nimo imo hindi pa subscribe either sa fiscal or sa duly authorized person like the notary public, subscribe nimo, and then ang contents mo affidavit that you have made it subscribe to is mali, dili mao, false jud, no? Mo na diha nagpa-subscribe ka, napa-notarize ka sa imo ang affidavit, tapos mali na imo ang statement dito, igo jud ka diri sa Article 183. The penalty of arresto mayor in its maximum period to prison correctional in its minimum period shall be imposed upon any person who knowingly making untruthful statements and not being included in the provisions of the next preceding articles shall testify under oath or make an affidavit upon any material matter before a competent person authorized to administer an oath in cases in which the law so requires. Any person who in case of a solemn affirmation made in lieu of an oath shall commit any of the falsehoods mentioned in these and the three preceding articles of this section. At the mga false testimonies, three preceding articles, no? 182, 181, o 180, shall suffer the respective penalties provided therein. So, mura po gyapon ni siya false testimony, pero perjury na ang tawag aniya. Kaya na second paragraph, any person who in case of solemn affirmation made in lieu of an oath shall commit any of the falsehoods mentioned in these and the three preceding articles of this section shall suffer the respective penalties provided therein. Naman tayo mga respective penalties sa Article 180, 181, 182, no? Maunto ang iyang maiguan. Okay. Two ways of committing perjury. One, by falsely testifying under oath. And two, by making a false affidavit. Falsely testifying under oath should not be in the judicial proceeding. This should not be in the judicial proceedings, no? Falsely testifying under oath. Ay nga naman, kung judicial proceedings siya, ito maigo sa 180 o 181, 182. Ito sa criminal cases o civil cases o other cases dito sa court. So, falsely testifying under oath. So, but all in all, this particular article is called perjury, no? Perjury. False testimony in other cases and perjury in solemn affirmation. Elements of perjury: that the accused made a statement under oath or executed an affidavit upon a material matter. That a statement or affidavit was made before a competent officer authorized to receive and administer oath. And that in that statement or affidavit, the accused made a willful and deliberate assertion of a falsehood, and that the sworn statement or affidavit containing the falsity is required by law. Kung dili siya gina-require by law, then it may not be violating this particular article. Oh. What is an oath? An oath is any form of attestation by which a person signifies that he is bound in conscience to perform an act faithfully and truthfully. It involves the idea of calling on God to witness what is averred as truth, and it is supposed to be accompanied with an invocation of His vengeance or a renunciation of His favor in the event of falsehood. Because when you testify, before giving your testimony, ipakuan sa kang under oath. Do you swear to tell the truth and nothing but the truth, so help you God? Ana man na siya. Yes, Your Honor, I swear to tell the truth and nothing but the truth. Mag-ana ka, ano oath, no? Under God. In fact, ang pinaka-formal yun, ana ka, tapos ang imong isa kamot na sa Bible, muna ang formality sa pag sworn under oath before testifying before the court. Under oath. So, sa mga affidavit. Affidavit is a sworn statement in writing, a declaration in writing made upon oath before an authorized magistrate or officer. Notarized ni siya kanang affidavit, no? Statement under oath as the basis of the charge of perjury. Being made a statement falsely charging O with staffa, that is, that the latter borrowed from him an English manuscript entitled Manual of Exercises on Correcting Everyday Errors, and that when he demanded its return or denied having received it, be made it under oath in the preliminary investigation before the Justice of the Peace, a competent officer authorized to administer oath. This statement constitutes a material matter and is a deliberate falsehood because O never borrowed the manuscript. Held, B is guilty of perjury. So, ano siya? Basta fiscal. Before sa fiscal siya ng under oath eh. False affidavit as the basis of the charge of perjury. The accused Rofo B. Cruz filled up a blank application of Civil Service Form number 2 for the patrolman examination. He stated therein that he had never been accused, indicted, or tried for violation of any law, ordinance, or regulation before any court. When in truth and in fact, as the accused well knew, he had been prosecuted and tried before the Justice of the Peace Court of Cainta Rizal for different crimes. The application was signed and sworn to by him before the Municipal Mayor of Cainta Rizal. Held, the crime committed is perjury. The offense as defined in Article 183 of the Revised Penal Code is the willful and corrupt assertion of a falsehood under oath or affirmation administered by authority of law on a material matter. I have a very, very personal experience on this, no? It involves the brother of my former boss who applied for a judge, RPC. There's an abo. Oh? God bless his soul. Namatay naman to siya. Tamaan sa diabetes. Anyway, he actually practiced as a judge, no, for several years. No? After filling up that particular form for his application for a judge, no, and then you know who notarized the application? It was me. Kaya parehas mami office. So ano ganin sa akong amo, no? Under basta before ko nag private practice ako solo on my own, I have been with another particular lawyer, no? Understudy ko niya. And it happens na isang brother dapat na opisina silang sa building. Ano ato sa ako, Bibs, ma-apply ko kuan judge. Pakipirma ko pa kay authorize ko aning kuan bi. Notarize ko, siyempre. Notarize ko kay kuan man, mga amo man, mga senior man sila. Notarize. Amigo po na ako sila. So I notarize it with the entry there. But then, siyempre, wala na ko yung particular sa mga entries dito. Basta kikinotorize na ako. When it was submitted to the court, luckily, his application along with the other documents that he submitted satisfies the qualifications of being a judge. So, he was admitted as being a judge by the Supreme Court and he became a judge. He practiced, he was a judge first in Jinsan and then later on transferred to Davao City. Judge Sadrid. But ang iyang pagka-judge is such that so strict. Strict yun siya, mga judge siya. Hindi siya pwede magkuhan. Siya pakuhan ganit. So, giinitan siya. There are several lawyers na irks ang the way he disrespect the practitioners before sa court, kasapaan niya, ano ba? So nagi judge nga, nagi mga lawyers, sa lawyers dito nga nag-file og anonymous complaint, and then finding out na point out niya dito nga isa sa entry sa iyang application to become a judge is this entry naaba kay may putana, naaba kay criminal case, naaba kay charges sa imuha nga gi-file. Ningo man siya nandito. Pero ang tinood na gid ay, and then it was recorded, na-record nasa kwan. Nagipang file sa iya administrative as well as criminal charge. Naka-mention dito sa complaint sa iya ha. And then vis-a-vis application giputang niya nan, and then notarize pa yun nako. Ako pa yun nag-notarize ha. Nakabot yun dito sa korte ako pangalan no. Supreme Court nasa libro sa Supreme Court report annotated. Attorney Bustamante mention yun. Attorney Bibiano Bustamante notarize the same. And so naka-violate siya ani ang particular perjury actually. And perjury being one crime which is detrimental to public interest. Actually, inatawag niya siya against moral turpitude, no? With moral turpitude ang crime ng perjury along with kanang mga estafa, kawat, ay moral turpitude. And you cannot be admitted as judge to any other position as judge kung nakakay kaso belonging to moral turpitude. And instance ay moral turpitude, perjury. So, dili ko siya dapat dito. So, i-conceal man niya nga kuan. I-conceal man niya nga circumstance. Na-point out yun. So, naka-violate siya. And then, he was dismissed as a judge actually, eventually. Dismissed siya as a judge. Tapos, ulaw na siya ma-practice. No? Ulaw na siya. Di na siya pakita dito. Eventually, he died. Because of this lingering diabetes sickness of him. So, wala pa to siya na, wala to siya, dalapot siguro niya, ang ibati siguro. Gabi po to siya, about sa pwede yung kaagi sa una, bright boy ba to? Bright na tao to. Maigod siya. Maigod siya sa iyang discussion, sa court, litigation. In fact, kung mag-appear ko sa iyang kaso, basta equal lang ang argument naman sa laing counsel, he will let me win the case. So to say panalo yung ko sa iyang korte perme. Although I would put in record ito nga I was the partner or one of the staff sa iyang isuon nga law office, and then let the other counsel let them know nga inana tapos mao na ang relation namo sa judge. So I would want to whether the other counsel will want me to transfer the court hearings to other judge kay murag naay bias on niya ba. Ang other counsel so happen dili man siya okay ra man saya kay kabalo man siya sa kabalo man siya sa kuha, kabalo po sa judge. So okay ra gyud saya. So let the judge decide. And so the judge allows me equal lang may preponderance of evidence nga mga kaso makadaog yun ko, dili yun ko pahirapan parte sa procedure, di ko mahirapan because the judge knows me very well. But so happen nga nakadimalas lang yun siya katong panahon na nasa kaso nga criminal administrative case, napa siya ato sa National Police Commission. Tapos wala na gi-consel niya na siya kaso dito pag-apply niya judge. That was the cause of his downfall, no? Material matter defined. So kung mag-testify ka, false testimony niya, dili siya material matter, it doesn't matter, wala kay violation. But if it is along with the material matter na testify ka, you're testifying falsely, then that would matter, no? It is the main fact which is the subject of the inquiry or any circumstance which tends to prove that fact, or any fact or circumstance which tends to corroborate or strengthen the testimony relative to the subject of inquiry, or which legitimately affects the credit of any witness who testifies. So example of material matter in case of People versus Bautista. The material matter that is the main fact which was the subject of the inquiry by the Justice of the Peace was whether the offended party borrowed the English manuscript. Same case, no? The testimony of the accused that the offended party borrowed it from him was upon that material matter. If it was true, then the charge of estafa would prosper. If it was not true, the complaint for estafa would be dropped by the Justice of the Peace. Pero baliktaron po siya kaning kaso ng perjury. No? So, igo siya yun, no? This material matter. There must be competent proof of materiality. Where materiality is a statutory element of the crime, it is settled that there must be competent proof of the materiality of the false testimony. Material, relevant, pertinent, distinguished. The matter is material when it is directed to prove a fact in issue. Like, ang issue is, namatay siya, dunggab. Muna. Ano yung mga material da, no? It is relevant when it tends in any reasonable degree to establish a probability or improbability of a fact in issue. So, solid na diri ang circumstantial evidences. It is pertinent when it concerns collateral matters which make more or less probable the proposition at issues. Igogyapo din sa circumstantial evidences. So, kinsa man ni mga competent persons authorized to administer oath. Usan na nila ang mga notary public. At most, ang mga prosecutors. The phrase competent person authorized to administer an oath means a person who has a right to inquire into the questions presented to him upon matters under his jurisdiction. Okay, fourth element, it is necessary that there be a specific provision of law requiring the affidavit or sworn statement to be made. Kung walay nag-require nga balaod nga kailangan affidavit, then even if you have stated falsely in that particular affidavit, you will not be charged with perjury. Okay? To induce the clerk in the office of the municipal treasurer to issue a certificate of transfer of a large cattle, the accused executed an affidavit wherein the latter swore falsely that he was authorized by its owner to sell it. Held, the affidavit could not be made the basis of perjury for the reason that the execution or filing of such an affidavit was not required by law. So the basis of this ruling is the phrase in Article 183, which is, shall testify under oath or make an affidavit in cases in which the law so requires. A sworn statement containing a falsity made by a witness in preliminary examination which leads to the issuance of a warrant of arrest may constitute perjury because the revised administrative code requires that in a preliminary investigation of a criminal case, all the witnesses, including the complainant, must be examined under oath. Examples of cases where affidavits are required by law are affidavit attached to the petition for receivership, affidavit attached to complaint for ejectment, an affidavit for application for marriage license. No. However, in an unpublished decision, it was held that the word requires in the phrase in cases in which the law so requires may be given the meaning of authorizes. Hence, the fourth element may be read that the sworn statement containing the falsity is authorized by law. So even if there's no law requiring the statement to be made under oath, as long as it is made for a legal purpose, it is sufficient. So, but then, unpublished ang kaso noon under our GR number L47693, October 12, 1943 nga kaso. You read this one. People versus Angangko. Subornation of perjury is committed by a person who knowingly and willfully procures another to swear falsely, and the witness suborn does testify under circumstances rendering him guilty of perjury. Kanagaling kasagaran maiguan yung subornation of perjury. Mula na yung istoryahan. Yung lawyer, i-testify ka sa lawyer, no? Instead na kanina may istorya, kanina yung istorya. Ana ba? So, subornation of perjury. Tupod siya. Tulad siya sa imwa, perjured na di ay. Di ba? Subornation of perjury is not expressly penalized in the revised penal code, but the direct induction of a person by another to commit perjury may be punished under Article 183 in relation to Article 17. Offering false testimony, 184. So, in evidence. So, offering false testimony in evidence. So, kung false testimony niyo, offer niyo, kasagaran makasalaan niyo kanang mga lawyers, no? Before having to testify in court, before the court, before siya i-presented to, ang lawyer mo offer sa siya sa testimony, honey. I'm offering the testimony of the witness to prove the following circumstances: that he is the complainant in this case, that he saw the event that transpired that particular day, in that particular place, so on, so on, so on. So, mana ang pag-offer niya sa testimony before the witness may be allowed to testify. So any person who shall knowingly offer in evidence a false witness or testimony in any judicial or official proceeding shall be punished as guilty of false testimony and shall suffer the respective penalties provided in this section. So element ani is that the offender offered in evidence a false witness or false testimony, that he knew the witness or the testimony was false, that the offer was made in a judicial or official proceeding. Siyempre, kaning number 2 dire, this is very subjective, no? Pwede mo i-deny, I don't know that the testimony was false. I was just presenting him, that was what he told me, that I believe him. So kung i-believe lang kasi yung storya siya, tapos wala ka lang itong mali siya, then that is subjective, no? Arguable ka siya. Pwede siya i-debate, debatable siya ng issue, no? So how would you know that I knew that the witness is false and he's giving a false testimony? No? Well, in fact, I did not even know that his testimony is false. Dali mo yung rason. So, nothing much really is being convicted under this particular provision if you don't know that he knew that the witness or the testimony was false. Okay? And penalty is that for false testimony if committed in a judicial proceeding, or that for perjury if committed in other official proceeding. The accused shall be punished as guilty of false testimony and shall suffer the respective penalties provided for false testimony or perjury, as the case may be. Offer of evidence under Section 35, Rule 132. You will learn this when you are already in the subject of criminal procedure, no? Under rules of court. Insofar as testimonial evidence is concerned, begins the moment a witness is called to the witness stand and interrogated by counsel. The witness must have to testify. Is a person who presented a false witness liable under Article 184 even if the false witness did not testify on any material matter because the latter desisted from testifying? It seems that the person who called to stand a false witness is liable for attempted offering false testimony in evidence. While Article 184 speaks of a false witness or testimony, that article requires to consummate the offense that the witness or the testimony must be offered in evidence. Even if there was conspiracy between the false witness and the party who presented him, the witness having desisted before he could testify on any material matter is not liable because desistance during the attempted stage of execution is an absolutory cause which exempts him from criminal liability. The party who presented him not having desisted is criminally liable, no? Hindi siya, no? Ang nag-present ani, may liable. Katong witness nga nag-desist will no longer be liable for false testimony. The one who presented him is guilty of attempted false testimony under this particular ruling.